can see readily there's an opportunity for you to go become a certified access specialist, and I'm sure that those will be popping up momentarily on the internet. Another opportunity to get a certification for someone. And actually there are, this job category has been around for a few years, and these folks become expert witnesses in litigation over parking lot access, over whether signage was correct in a parking lot, and this is sort of a spin-off of the Americans with Disabilities Act, but California also has a very robust set of rules on handicap access as well. They go well beyond what the ADA does. So have I succeeded in making you happier realtors?
No.
Yeah.
Questions? Yes, sir.
The question I have is on the energy qualification. Is there a company, is that like a first rating? Do they set what decides what is of energy efficiency? Is it like based on what? And also on the second question, do either one of those domestic partnerships or community property with right of survivorship affect the sellability of a property? I mean, it's pretty much when you say husband and wife, you need to know that everybody has to sign on the escrow and the listing. On some of these partnership things that are not disclosed on title, do we now need to just upright in front ask, or I mean, how do we tastefully get into that? Are any of those do require two signatures?
The question was with respect to the energy use issue. How do you? What are the standards? And the second is on the sale of property by someone who is a member of a domestic partnership, or not, or perhaps a member of a couple, maybe not a member of a couple. How do you know these things? Well, you don't know unless someone asks. You don't know the answer with a domestic partnership any more than you know whether the person is married. The fact that somebody is in a couple doesn't mean they are married, and there's a difference. There is no such thing as common law marriage in California. Never has been. Doesn't matter how long you've been together, you're not married unless you're married. You're not a registered domestic partnership unless you're a registered domestic partnership. The parties may have other kinds of claims and obligations to each other, but they're not married or members of a domestic partnership unless they are in fact that. So the way that gets sorted out in real estate sales is the statement of information that is usually done a couple weeks before escrow closes. There's a statement of information or confidential information statement that escrow sends you, and you have to fill out all of these questions. Where you've lived, what your full name is, are you married, how was your last marriage or domestic partnership dissolved, and the function of that is, number one, of that form is to, number one, figure out which John Smith you are, because there are many people out there, maybe with judgments against them or bankruptcies or in the middle of divorces, and a lot of people have similar names. So the title company runs a search to determine whether there are legal issues out there hanging against a person. And the way they sort out the names is with a statement of information that you sign under penalty of perjury, saying I pinky swear that I'm telling the title company and escrow the truth. So if you don't, until someone asks that question, are you married or are you a domestic partnership, you can't know the answer to that. You can't determine whether they're married or domestic partnership based on title, because they may have acquired title before marriage, and even if it was after marriage, you can't tell that anyways. Many people don't follow the rules and don't put their spouse on title or their domestic partner on title. Many people aren't aware of all of these rules. But the place where the rubber meets the road is escrow, toward the close of escrow. If you can ask the question, But you're not, there's no point at which you must ask the question, but it happens before escrow closes. Yes, sir.
What kind of inspections required in the sale of industrial, commercial property where there may have been chemicals or stuff like that on the property, and you have to test the drills or
What the question is, what kind of inspections are required on industrial or commercial property to test for the various things that could be there? Could be petrochemicals, could be heavy metals, could be a lot of other things. The place that this usually gets mandated is through the financing process, because any lender, if you're getting new financing, they're going to require at least a phase one, which is phase one means an inspection of public records, review of public records to determine whether a prior use of the property may have created a contamination. If it was shown as a prior auto dealership or a gas station or a metal works, then there is a reasonable chance that there might be some kind of contamination. Any lender nowadays, if it's a commercial, a regular lender, is going to require at least a phase one to determine whether that's the case. Phase two is required if the lender has reason to believe, or someone in the transaction has reason or suspicion, or wants to know for sure, is there some contamination? Is there methane? Is there chromium? Is there some kind of chemical pollution on the property? So phase two means a sampling of the property, where there are environmental engineers that are readily available and other consultants that go out, sample soil or sample the air that's coming through soil, and try and extract whatever they can to see if there's some kind of contamination. And then if there is, phase three means doing remediation work. So these are all contractual issues. Primarily they're contractual issues, and they are financing issues, that meaning that a bank is not going to make a loan nowadays unless they're satisfied that the items in their checklist have been taken care of, and that includes making sure that that there's no apparent contamination. Ma'am.
Okay, on the Affordable Care Act, you said the 3.5% applies to now passive income as well as earned income?
Yes, 3.8.
3.8, and that's effective?
January 1, 2013.
Okay, thank
That question was, what are the guidelines for the 3.8% Affordable Care Act tax on unearned income? There's also an income threshold that doesn't apply to someone who has whose adjusted gross income is beneath a threshold. If you hit the threshold, then it's 3.8% of an additional tax to fund affordable care.
On the LLCs and the LPs and all those, clearly they still have to do a transfer disclosure statement. Is that correct?
The question is, sales by a limited partnership or limited liability company or some other entity, do they have to provide a transfer disclosure statement? Short answer is yes. The fact that the seller is not a live human being does not relieve them from having to give a transfer disclosure statement, which generally is required on a 1 to 4 family residential property. The slightly longer answer is that there's an exception for trusts, that the sale by a trust or a sale by the trustees of a trust is exempt from a transfer disclosure statement, but it is not exempt from the agent or broker's duty to do a careful visual inspection of accessible areas and disclose the results of that. So if the seller is a trust, for example, the adult children of 2 homeowners who lived in the property and both homeowners are deceased, they put the property into a trust, their 2 adult children are the trustees of a trust. Technically, the trustees are exempt from having to give a transfer disclosure. But if they have personal knowledge of the answers to these things, as the adult children of the deceased owners may very well have, they may very well have personal knowledge of defects, then they have a personal, they still have an obligation to disclose the knowledge that they actually have of adverse material conditions that would affect value or desirability of the property. So, either way, the realtor, the agent, has to give a disclosure of the results of the agent's careful visual inspection. That can be done on the AVID form, which is Agent's Visual Inspection Disclosure. Could also be done on the Real Estate Transfer Disclosure Statement form. And also what I would say is the fact that the seller, if they're a trustee of a trust, it may be exempt from having to give a transfer disclosure statement. That's not a good reason for not making disclosures. If they, as I said, if they have knowledge of anything, personal knowledge, they've got to disclose it anyway. And I'm a believer in not over-relying on exemptions. If the seller is willing to give a transfer disclosure statement, they can certainly do that, and it reflects that they're not, perhaps reflects that they're not trying to hide something. Now, otherwise, sales of property by entities doesn't make any difference. The fact that it is a limited liability company that owns a 1 to 4 family property, maybe the LLC acquired it, fixed it up, and is flipping it, the seller still has to give a TDS. However they choose to answer the questions, they may never have lived in the property, may not have knowledge of certain things. You can say that as you would in any other disclosure document, and encourage buyers to do their own careful visual inspections using professional inspectors. But at the end of the day, the seller is obligated, other than a trustee. The other exemption that comes to mind, and there are more. One that comes to mind that's fairly common is that a lender who forecloses on a property is exempt from having to give a transfer disclosure statement on that sale. So the first sale, following the lender's completion of a trustee's sale, foreclosure, or court foreclosure, either way, the first sale is exempt for that lender. Now, once the lender transfers the property off to some other lender or to some REO entity, that's no longer a sale. When that transferee sells the property, that transfer is no longer exempt. It's the first sale by the lender who reacquires the property through the foreclosure. That first sale by that lender is exempt.
Okay. I got a little confused. So a trust is exempt from the...
Then I was successful. Okay.
Okay. A trust is exempt from the transfer disclosure statement, but we can still ask them to fill one out, even though it's exempt, just to see whatever they know?
They can give the question is, a trust is exempt from the requirement under California law of giving a real estate transfer disclosure statement on the sale of a 1 to 4 family property. Other court sales are also exempt. So probate, in which there's an executor or administrator selling the property, that's exempt. But likewise, the agent has the same duties to do careful visual inspection and disclose the results of that. But the seller can fill out the transfer disclosure statement form, and if you have a circumstance where the trustees lived in the house, grew up in the house, and have personal knowledge of the property, then it's an example of a circumstance where I would encourage somebody to make those disclosures. If they lived in the house, the likelihood is they're going to have more knowledge than just some other third-party trustee. Yes, sir.
If they're exempt and you fill out that form, can they be liable for not putting something in, maybe they'll get something?
Well, the question is if the seller's exempt but fills out the transfer disclosure statement form anyway, can they be liable for missing something in what they fill out? Anyone who gives a disclosure who doesn't disclose all of their actual knowledge of adverse material conditions that could affect value or desirability of the property is potentially liable to a buyer who says, well, you knew and you didn't disclose. Now, if you did not know, the standard of knowledge in a transfer disclosure statement is actual knowledge. It's a good faith, actual knowledge standard. So if you did not know that 20 years ago someone built a room addition, did not get permits, and the room addition was built without compliance with code, which is a separate question from whether it complies, whether it was done with a permit. If you don't know that, you're not obligated, a seller is not obligated to find that out. And it says that right in the transfer disclosure statement. So whether you're giving the transfer disclosure statement, even though you're, say, a trustee making this disclosure, and perhaps you don't really have to fill that particular form out, or you're just any other seller of a residential property and you do have to fill out the form, if you are not honest in how you answer the question, you have potential liability. If you do not know something, that's not being dishonest. That's, I don't have knowledge of it, and you do not have an obligation to find it out. The exceptions on things that you have to, that you are expected to know are few. If you don't have actual knowledge, you don't have liability in most circumstances if you're the seller. And one of the big categories of exemption is of the exemption from what I just said, meaning a seller who doesn't make a disclosure of the following things does have a liability, even though he or she doesn't know it. And that would be the natural hazard disclosure. That's why you should your clients should always be obtaining a natural hazard disclosure from a third-party source, because there's no practical way for a seller to go look at maps of different kinds of geologic or other hazard areas and decide, well, okay, the property's in this zone or the property's not in this zone. Yes, sir.
On the realist, what they're doing now is that an agent would put down a 4-bedroom, 2-bath, and the assessor may have it as a 3-bedroom, 2-bath or something. So a realist is starting this, combining the two. Now, if somebody has gone through and done some changes, and it's apparent, but the assessor is still saying it's one less or it's different, and you disclose that on either TDS or the visual, is there a secondary form? Because I've heard, and I'm familiar with certain cases where it was apparent, it was sold as a certain 3-bedroom, 2-bath, yet there was a 4-bedroom configuration, and then the new buyers wanted to come in and they wanted to sell it as a 4-bedroom, 2-bath, and there wasn't enough permits or something. So it then becomes a situation, though, even though it appraised and everything, when they bought it, they're now wanting it to be even better. Is there a third kind of disclosure as agents we should be doing?
The question is how to reconcile the difference between reality and what the county assessor shows as number of bedrooms.
The seller thinks they're getting, in fact,
Right.
when
But
you're selling.
the same issue is there for square footage and for other amenities of properties. The county assessor basically takes their information off of what was originally reported when a building permit was obtained or finalized. That's when properties initially reassessed, is when a construction is finished or a room addition or something like that. Room additions are sometimes done with no permits, obviously, and sometimes construction changes in the middle, even though there was a permit for a 4-bedroom. Maybe the parties got a larger room and had one fewer bedroom, or maybe there's an error. Maybe there's simply an error. Now, a couple things. It's very easy to have the assessor change the number of bedrooms. It's quite easy. There's a form, and in the case of LA County, you can go online and the homeowner can fill out a request to change the reporting, either number of bedrooms or square footage. and I think you can file it online now in LA County at least. All of this is county to county. But the fact is that no matter what the county assessor says, the assessor may say it's a 2,500 foot home, and the homeowner insists that it's a 3,100 foot home, and you just have to be very careful how you're disclosing information. And the civil side of this is the risk here, the claim here is negligent misrepresentation. Negligent misrepresentation means that you make a statement of a fact and you think it's correct, or maybe you think it's correct, and you say it in the multiple listing service or in a flyer or in some other disclosure, and you say the property is a 3,150 square foot home. And you got that information from the seller, or you got that information from a flyer that the seller got when they bought the property. But the county says the property is 2,900 square feet, or whatever number they say. Negligent misrepresentation means you make a statement thinking that it's true, but without what the law would say is an adequate factual basis for thinking that it's true. So that is in the eyes of the beholder. That's whatever the plaintiff's lawyer says, or a jury or an expert witness says, well, I would never have relied on that piece of information. I would always go do such and such. I would always go get an appraiser to go properly measure the property, or an engineer or something. You just have to, the key to disclosing factual information that you don't really have a personal knowledge of is to cite your source. It's true with everything. How old is the roof? Was the entire attic wood structure replaced when that small fire occurred? You have to cite the source of whatever you're saying. So if you say, for example, there's major cracking in plaster on the side of a house. If you say there's cracking on the side of the house, I don't know what the source is, buyer is advised to have that inspected and determine that, you are fine. And that happens to be the example of a case called Robinson versus Grossman, in which the agent said that. There's cracking on this set of areas. I don't know what the source is. I'm not going to check it out. You should. So the buyer finished the purchase and then, of course, sued the agent for not figuring it out and not telling him what the cause was. And the Court of Appeal said that the agent did it exactly right. What else are you supposed to do unless you're an insurance company? There's a difference between being an insurance company and responsible for something that goes wrong that you're not responsible for, versus being a real estate agent and doing the right thing. If you cite the source of your information, so for example, back to what you raised, which is what if the apparent number of bedrooms is 4, but the county assessor says 3, or the square footage is off, or something else like that. When you put it in the multiple listing service, you need to cite your source. So most multiple listing services auto-populate square footage, in which case there's a code that says that comes from public records. Public records usually means the county assessor. That's the predominant source of public records. If you're going to override that, you need to be saying what you're basing that on. And in remarks at least. Yes, sir.
Okay, just real quick, one final question for the sake of time. Freddie, to be the final question.
What about that of an occupant on the property? If you're aware of that as an agent, you disclose it in MLS and put listing it, or wait till the disclosure once you're in escrow, because the values could be way different.
Question is death of an occupant and disclosure, and are you obligated to disclose that in the multiple versus disclosing it at some other point, typically a real estate transfer disclosure statement? There's no requirement specifically that you disclose it at the multiple listing stage, but you certainly have to disclose it to the buyer. What I know is they're definitely going to find it out. If you're talking now, are you talking about a death less than 3 years?
Yeah.
Okay, so California law says that if a death occurs on real property less than 3 years prior to the sale, you have, it doesn't say it this way, but the short way of explaining it is you need to disclose the fact that a death occurred on the property. The law really says that you can't, that a buyer cannot successfully sue you for failing to disclose that a death occurred on real property more than 3 years ago. It doesn't really come out and say you must disclose it if it's a death less than 3 years. The only way to do this, if you want to remain in this business and not be sued, is if you is disclose the fact that a death occurred less than 3 years ago, whenever it occurred. And in fact, even if it occurred more than 3 years ago, the bottom line is the buyer will soon find out that a death occurred in the property as soon as the welcome wagon person comes by with, you know, tickets for local businesses, and oh, by the way, you did hear that the family, you know, died in a meteorite attack, or whatever it is. I mean, whether a particular death is significant or not depends on the buyer, depends on the person. It's cultural, it's religious, it's personal, philosophic, and what I know is you can't get into trouble for disclosing the fact that a death occurred on the property, and you can get into trouble for not disclosing it. This, that statute is the result of a lawsuit called Reed versus King, in which case the buyer asked specifically whether there was a death on the property, and they lied. And so that's pretty obvious nowadays that, you know, that's not a strategy for long-term success in real estate. You know, you have to be honest, you have to disclose what you know, and move forward. So you could disclose that. There's no question for that particular question in the transfer disclosure, but there is in the SPQ, I think. The Supplemental Property Questionnaire has a question in it of whether a death occurred in the property, and if you know it, disclose it, you'll be happier. Thank you, ladies and gentlemen. It's always a pleasure.
We stay for a few minutes.